Good afternoon, members, and welcome to the meeting. Unfortunately, due to unforeseen circumstances, the chairperson and deputy chairperson have submitted apologies for this meeting. However, standing orders do not require the elected chairperson or deputy chairperson to be present at every meeting of the committee, and if there's a quorum, the members present can elect a temporary chairperson for this meeting. I advise members now that we do have a quorum, as we have Sinead, Gemma, Doug, Rachel and Robin present at the meeting. So I'm therefore going to invite nominations for a chairperson to chair this meeting. So if members would like to indicate. Doug?
Yes, if I would like to nominate Robin Newton as the deputy chair or standing chair.
Thank you, Doug. Sinead, I think you had indicated as well.
Chair, yes, can I second that?
Okay, thank you. Robin, as you've been nominated and seconded, you're now in a position for nomination to chair. Can I just check with members if there are any other nominations members want to make? Okay,
Please.
if there's no other nominations, then I need to put the question that Robin Newton do take the chair of the committee for this meeting. If members could indicate if they're content with that.
Great.
Thank you. Given that all members are content, Robin is now appointed as chair for this meeting. If we could just ask members to take their ease for just a second until Robin gets himself organised. Okay. Thank you.
Then we're just moving to one advice to members. Okay, members, thank you. Well, I'm not sure whether it is thank you or not, but we'll continue with the meeting as best possible. But can I advise members that they're welcome to use mobile devices as long as they're in airplane mode and all devices are muted, as I think most members know this can connect with the Assembly Wi-Fi. Remind members also that they are obliged to declare any financial or other relevant interests which might reasonably be thought by others to influence their approach to the matter under consideration. Any members who have interest to declare in relation to today's business should do so now or when the particular matter arises at the meeting. Can I ask, are there any members who wish to declare an interest at this stage? No members are indicating. Thank you. Members, can I seek agreement of the members for the oral evidence session on abortion services Safe Access Owns Bill to be recorded by Hansard and the transcript published on the committee website? Members agreed? Members have indicated agreement. Okay. Item number 1 then, formally on the agenda, is apologies. We have apologies from Mervyn Story as chair, Sinead Ennis as deputy chair, Emma Rogan, member, and Peter Weir, member. Can I advise members that Sinead Bradley, Gemma Dolan and Doug Beater are joining by Starleaf and welcome them to the meeting. Myself and Rachel Woods are obviously here in person. I invite the clerk to advise members which members have indicated, if any, delegated authority to vote on behalf as provided by standing order.
Under Standing Order 1156, Mervyn Story and Peter Weir have delegated their votes to Robin Newton, and Sinead Ennis and Emma Rogan have delegated their votes to Gemma Dolan.
Okay, thank you, clerk. Agenda item 2 then, we move to the draft of the minutes held on the 14th of October 2021, and I refer members to pages 5 to 13 of their meeting pack for the draft minutes of the meeting on the 14th of October. Ask members if you are content that the meeting's notes are a true reflection of the proceedings held on that date. If so, members agreed? Members agreed? Agreed. Members have agreed. Thank you. Agenda item 3 then, matters arising. Can I raise one item? Examiner of Statutory Rules report. Remind members that at the meeting on the 7th of October 2021, the committee considered Statutory Rule SR 257-2021, the Postal Administration Rules Northern Ireland 2021, which provides the procedure for the special postal administration regime in the event that a company providing that service is at risk of entering insolvency proceedings. The committee noted that aside from a minor drafting issue, which the department had indicated it would address, the examiner of statutory rules was content that the rule would not otherwise be drawn to the special attention of the Assembly. On that basis, the committee agreed that it had no objection to the rule. Can I advise members that the examiner published her report, which confirmed this position on Friday the 15th, and a copy of that is at pages 15 to 22 of the meeting pack. Can I ask, are the members content to note the examiner's report?
Agreed.
Members content? Members
Content.
content. Thank you. Item 2 then, the committee forward work programme. Remind members that at last week's meeting, the committee agreed to schedule a number of work items requested by the Department of Justice in November and the informal deliberations on the Protection from Stalking Bill on the 4th of November. I advise members that a committee forward work programme for November reflecting the work items agreed at last week's meeting is at page 23 to 28 of your meeting pack for information. Okay, we move to item 3, response from the Minister of Health on the damages return on investment bill. Remind members that the committee wrote to the Minister of Health regarding several issues he had raised in the context of the damages return on investment bill, including the potential impact of the change in the personal injury discount rate on the provision of health and social care and the cost of indemnity for GPs. The Health Minister has replied, and his correspondence is at page 3 to 4 of the table pack. The Minister has indicated that no decisions have yet been taken about any future arrangements for GP indemnity provision in Northern Ireland, and therefore there have been no discussions with Treasury to date on funding. Can I ask you members to note that response and seek any clarification or further information that you may require? Members content? Members are indicating content. Okay, we move to item 4 of the agenda, Abortion Services Safe Access Zones Bill, oral examination session with Clare Bailey, MLA. Can I inform members that Clare Bailey will attend the meeting today to give brief members on the provisions of her private members' bill on Abortion Services Safe Access Zones Bill, which passed stage 2 on 12th of October and has been referred to the Committee for Health to undertake the committee stage. Given there are parts of the bill relevant to justice, the Health Committee is likely to request evidence from this committee on those parts, and the relevant pages are 30 to 92 of today's meeting pack. Can I welcome Clare to the meeting? Nope.
We're going to take the other agenda items first.
Sorry, I'm being advised here. We're going to take other agenda items first. Sorry. Let me just go back to you members then. Move to...
Sorry.
Right. Okay. Sorry, members. This is really in connection with our very small number in attendance today, and to advise you that to ensure the quorum is not lost when the committee is taking decisions, can we defer item agenda 4, the oral briefing from Clare, until 2:45, and then that allows us to take some of the other agenda items first. As I understand, Sinead Bradley will have to leave the meeting at that time for approximately 30 minutes. Am I right on that, Sinead?
Yes, Chair. Thank you.
Okay, so can I advise members that the committee can take oral evidence with 4 members present, as no decisions are being taken? Can I seek agreement from the members that we do adopt that approach?
Agreed.
Agreed.
Agreed. Okay, thank you members for that. Okay, we're moving to item
5.
Item 5. Thank you, Christine. Item 5 then, the damages return on investment bill, the draft report. I refer members to pages 15 to 174 of the table pack for the draft committee report on the damages return on investment bill and the draft executive section. Members will note that at the committee stage, if this bill ends on Thursday, the 28th of October, given there is no committee meeting planned for next week as it's Halloween recess, members were asked to submit any proposed amendments to the report by 4 p.m. yesterday to enable those to be circulated in advance of today's meeting. I can advise members that no amendments were received for circulation. Can I also inform members that any typographical or formatting errors in the report will be amended at proofing stage before it is circulated to MLAs and published on the committee website. Advise members that you can assume there will be no proposed amendments and now seek the committee's formal agreement of the report unless the members indicate otherwise. Members content?
Content.
Right.
Members content? Okay. Okay.
Chair, sorry.
Sorry.
Can I agree with it? Sorry, but I just want to thank the committee staff for a fair and detailed reflection of the committee's considerations.
Thank you, Gemma. I think the committee staff would welcome that. Thank you. Okay. We're moving now to format for formal agreement of the report. The title page, committee membership and powers, table of contents and list of abbreviations. I refer members to the title page, the committee membership and powers page, table of contents page and list of abbreviations page of the report. And can I now put formally the questions? Are members content that the title page, committee membership and powers page, table of contents page and list of abbreviations page stand part of the report? Members content?
Content.
Members are indicating content. I refer members to the introduction section of the report at paragraphs 1 to 25. Can I put the question, are members content that the introduction section at paragraphs 1 to 5 stand part of the bill? Members content?
Content.
Members are indicating content. Consideration of the bill's provision stage. Can I refer members to the consideration of the bill's provisions section of the report at paragraphs 26 to 357? And can I formally put the question, are members content that the consideration of the bill provisions section at paragraphs 26 to 357 stand part of the bill? Members content?
Agreed.
Agreed.
Members are indicating content. Other issues raised in the evidence received by the committee on the bill section. Can I refer the members to the other issues section of the report at paragraphs 358 to 434? And can I formally put the question, are members content that the other issues raised in the evidence received by the committee on the bill section at paragraphs 358 to 434 stand part of the report?
Agreed.
Members content? Members are indicating content. Clause by clause consideration. I refer members to clause by clause consideration of the bill section of the report at paragraphs 435 to 445. And can I formally put the question to members, are members content that the clause by clause consideration of the bill section of the report stand part of the report? Members content? Members are indicating content. Appendices, I refer members to the appendices section of the report, and can I formally put the question, are members content that the appendices stand part of the report?
Agreed.
Members content? Members are indicating content. Executive summary. Can I refer members to the executive summary of the report? Can I formally put the question to members? Are members content that the executive summary stands part of the report?
Agreed.
Members agreed. Members content. Members are indicating content. Can I seek agreement of members for the report to be published on the committee website and issued to all MLAs and the Minister of Justice? Can I seek agreement of members for the chairperson to clear the draft minutes of this meeting for inclusion in Appendix 1 to enable the report to be finalised? The draft minutes will be replaced by the final version of the minutes once agreed by the committee. Can I seek the agreement of members to issue an electronic copy of the bill report to all the organisations and individuals who provided evidence to the committee on the bill?
Agreed.
Members agreed? Members are indicating agreement. I think we do wish to record our thanks. I'm sure that all members of the committee would want to record our thanks to Hansard and all the other Assembly staff, the department officials who assisted during the scrutiny of this bill. And we think we should put that on formal record. Members agreed?
Agreed.
Thank you. Advise members then that concludes the committee stage of the damages return on investment bill. And thank you. Then move to item 6, the Justice, Sexual Offences and Trafficking Victims Bill, proposals for oral evidence sessions. And can I refer members to pages 176 to 179 of the table pack for the relevant paper? Remind members that the call for written evidence on the Justice, Sexual Offenders and Trafficking Bill closed on the 24th of September. We received a total of 43 responses have been received, in which 34 make substantive comments on the bill. And the submissions have been uploaded to the electronic bill folder, the link for which was emailed to members on Monday the 18th of October. I can advise members that the clerk's memo at pages 176 to 179 of the table pack sets out proposals for oral evidence sessions on the bill. The intention is to schedule the oral evidence sessions for the meetings on the 11th, the 18th and the 25th of November. Can I seek the views of members on whether they are content to schedule the oral evidence sessions outlined in the clerk's memo, or whether they wish to remove any from the list, or indeed to propose additions to the list? I think members are silence is indicating content. Am I right?
Content?
Content.
Thank you, members. Advise members that once the evidence sessions then have been completed, the position can be reviewed to access any further oral evidence that may be required. Thank you, members. Agenda item 7, Police Crime Sentencing and Courts Bill, and it's a legislative consent motion. Refer members to pages 97 to 236 of the meeting pack for the relevant papers. I advise members that the legislative consent memorandum for the Police Crime Sentencing and Courts Bill was laid by the Department of Justice on the 25th of October 2021. Understanding Order 42A bracket 7. The committee has 15 days from that date to complete its report to the Assembly. The LCM proposes the extension of a number of provisions in the bill to Northern Ireland. Those provisions are outlined in paragraphs 3 to 10 of the clerk's memo at pages 97 to 101 of the meeting pack. I remind members that the committee received a briefing on the proposed extension to Northern Ireland of certain provisions in a forthcoming Westminster bill at its meeting on the 14th of January 2021. The department wrote to the committee following that meeting to advise that the proposed inclusion of the provisions relating to the location of human remains. The committee has since had ongoing and extensive engagement with the department and the Northern Ireland Human Rights Commission, as well as the Attorney General's Office and the Independent Commission for the location of victims' remains on these provisions. The committee was also advised of an amendment by the Home Office to include provisions relating to the amendment of POCA to extend freezing and forfeiture powers to electronic money and payment institutions. The committee had previously been advised that the Minister had written to the Home Secretary to determine a suitable legislative vehicle in which to include these provisions, and relevant papers in respect of all these issues are contained within today's pack. I remind members that the committee was also informed of a number of provisions which will now not be included in the LCM, including the extension of provision to Northern Ireland relating to the extraction of data from mobile devices and the use of audio and visual links in criminal proceedings. The committee has recently written to the department on these issues and can continue to pursue them outside of this LCM. I would formally like to seek the views of members on whether they are content with the proposal to extend to Northern Ireland, by way of an LCM, a number of provisions within the Police Crime Sentencing and Courts Bill relating to crime overseas, Production Orders Act, the management of sex offenders, the National Driver Offending Retaining Scheme, application of S29 of the Petty Sessions. Sorry, I'm being advised, Sinead, that you want to come in.
Sorry, Chair, yes, no, I won't stop you in your stride, but it was the reference to the pieces that have been extracted or left out, and it's about the extraction of data. Now, whilst I never favour LCMs as being a way of doing business, I have to concede there are times where it's required and there are times that it's in the best interest. But I won't pretend to fully understand what the view was of the executive to withhold or withdraw that piece around extraction of data from mobile devices. And I know we have liaised in the past, but I would really appreciate if we could continue to that and seek clarity on what the logic is there on why they're not wanting to include that piece. Thank you, Chair.
Okay, can I record it? Christine, can I?
Yes, Sinead, I think we have written to the department, but we'll write and seek further clarification of why the executive didn't agree to include it.
Okay, can we proceed with this then, or shall we?
Yes, well, if you're content, Sinead, we'll continue with the question because that's not actually in the LCM, so we can.
Yeah.
Okay.
Yeah, thank you, Chair.
Okay, you're content that we continue to put the question, Sinead, and then we'll get the clarification? Okay, thank you.
Yes, Chair.
But just formally let me put the question from the beginning again then, just so that we read it right into the record. I'll seek the views of members on whether they are content with the proposal to extend to Northern Ireland, by way of a legislative consent motion, a number of provisions within the Police Crime Sentencing and Courts Bill relating to crime, Overseas Production Orders Act, the management of sex offenders, the National Driver Offending Retaining Scheme, application of S29 of the Petty Sessions Ireland Act 1851 to the provisions in the bill enabling a judge in England and Wales to make an order authorising the police to obtain information about the location of human remains outside of a criminal investigation, and the application of an amendment to the Proceeds of Crime Act 2002 to Northern Ireland to bring electronic money and payment institutions within the scope of account freezing and assets forfeiture powers in Northern Ireland, or if any further information or clarification is required. You're content, Clare, as Sinead, that we now... okay. Thank you very much, members. I can inform members that a draft report will be prepared for consideration by the committee at the meeting on the 4th of November 2021. Thank you for that. Agenda item 8 then is SL1, the Magistrates, Courts and County Court Appeals, Criminal Legal Aid Costs, Amendment, Rules, Northern Ireland 2021. This report is within pages 238 to 298 of the meeting pack for the relevant papers. Members, at the meeting on the 23rd of September 2021, the committee considered a proposal for a statutory rule to amend the Magistrates, Courts and County Court Appeals Criminal Legal Aid Rules Northern Ireland 2009, which prescribe the remuneration payable to solicitors and counsel for criminal legal aid in magistrates' courts, cases and county court appeals. There is a statutory requirement to review the rules at least every 3 years, and the purpose of this statutory rule, which is subject to negative resolution procedure, is to give effect to proposals arising from the second statutory review. I remind the members that the committee agreed to request full details of the responses to be targeted to the targeted consultation launch back in July 2021, including any post-consultation report, and sought clarification of the reasons for the large increase in the fee for remuneration for counsel in appeals against sentence to the county court. I understand, Sinead Bradley, you want to make some comments around it? Is she gone? Sinead, sorry. Is she gone or?
No, she has. Oh, no, she's back in.
Yeah, I think
Back in.
we'll have to leave that one until...
Okay. Sinead, have you left us?
Sinead wrote in the chat, I don't know if you can see it, just she has to leave the meeting and will return ASAP.
All right, okay.
Right, we'll have to leave that decision then.
Okay, can we,
Can move back.
members, can we just leave that decision? And I understand that Sinead wanted to make some comments on that. So we'll come back to agenda item 8. Members content?
Sorry, we'll go back to the oral evidence session. Yeah.
Yeah, members are content. Okay, we'll then move to agenda item 9, SL1, Magistrates Court Amendment.
Sorry, Robin, we've lost the quorum. We need to move back to the oral evidence session.
All right, okay. Sorry, members, I understand now that we are below quorum, we do need to move back to the oral evidence session. And is it in person or?
Agenda item 4.
Agenda item 4.
If members would just take their ease for a couple of seconds until we see if Clare is available.
Okay. Okay.
Hello.
Hi.
Okay. Welcome, Clare.
Thank you, Chair.
Okay. Okay, Clare, welcome to the meeting. We are not quorate, so obviously there are no decisions that will be made on your evidence today. But we welcome you to the meeting and advise you that the session will be reported by Hansard, and the transcript will be published on the website. So can I ask you, Clare, to brief the committee on the abortion services, safe access zones, and in particular, their elements relevant to the Justice Committee?
Thank you very much, Chair, and thank you to the committee for having me in to speak to you about the bill. I greatly appreciate the opportunity and look forward to any feedback that the members might have. Obviously, you'll be aware then that this bill has passed second stage, passed with significant support, but I'm more than happy to give an overview of the bill and then take questions if that would be okay.
Okay.
Great. Well, listen, The reasons for why the bill is needed, I suppose I'll address first, and then what the bill seeks to do, and then look at the balancing of competing rights and the enforcement measures contained within it. Hopefully not take too much of your time, and then allow you the questions. Currently, women are facing harassment and attempts to impede them as they're trying to gain access to medical treatments and services, and this is happening regularly and more frequently outside reproductive and sexual health clinics and hospitals, also charities that provide information and counselling and other services. And the behaviours employed by those engaging in the activities really do cause distress, fear and upset, and a real risk of traumatising women and children with the use of graphic imagery, for example, particularly to those who've suffered miscarriage in the past. I've experienced it firsthand while I worked as a volunteer at Mary Stopes when they had their clinic in Belfast. And the fact that my services as a client escort were even needed should really signal the extent of the problems that women are facing when trying to access buildings. I have been spat at, I've been assaulted, verbally abused, called a murderer, splashed with holy water. I've had one young woman run into oncoming traffic to try and get away from the protesters. Regular recording of people without their consent happens, and this is used to threaten them as well. In my experience, I've heard that the recordings will be sent to the PSNI for prosecution, that they're working for the BBC and it will be broadcast on the television tonight, or that they threaten to upload it onto social media as well. So women really do have just the basic right to access healthcare without this type of fear or intimidation, and also in confidence. And staff also have the right to do their jobs without any abuse or harassment. And we wouldn't accept this outside any other healthcare setting. We shouldn't be accepting it in these instances either. The 2018 report of the inquiry concerning the United Kingdom of Great Britain and Northern Ireland under Article 8 of the Optional Protocol to the Convention on the Elimination of All Forms of Discrimination against Women concluded that women and girls in Northern Ireland had experienced grave and systemic violations of their rights as a result of restricted access to abortion. Among the specific articles of the Convention found to be violated were Article 10 and Article 12 for failing to protect women from harassment by anti-abortion protesters when seeking sexual and reproductive healthcare services and information. So it's within that context that this bill has been drafted, and what this bill seeks to do then is give the Department of Health the power to create safe access zones around any hospital or clinic that provides terminations or provides information, advice or counselling related to abortion. And this is hoped to prevent the type of activity that we have been seeing outside our hospitals every day that have acted as a further barrier to women accessing all sorts of family planning services and that have caused such distress and trauma to so many people, just even in passing, not always accessing services. And hopefully it will ensure the right to access those services in confidence. It will also significantly reduce the risk to all service users, so that does include staff and visitors to hospitals and clinics across Northern Ireland, from being impacted by the actions of protesters. And the bill will mean that those who continue to target women outside the healthcare centres can face consequences for their actions. It will create a criminal offence and they can be fined. The PSNI will also be able to remove people from the area. And then we're looking at the balancing of these competing rights for people. So it's not the intention of this bill or me to remove anybody's right to free assembly. So there is a limitation within those rights. So limiting the ability of people to interfere as they're trying to access any lawful medical services in confidence does not represent an undue restriction on our existing rights around speech, protest or assembly. They have every right to campaign for greater restrictions on whatever cause, and there's plenty of opportunities to continue to do that in locations without these negative impacts. However, the space immediately outside a hospital or a clinic should not be the space for this to happen. Women accessing pregnancy advice and abortion services, they're not seeking debate. They're merely trying to make their own personal decisions about their own reproductive choices, and they should be free to do that without fear of intimidation or harassment. And indeed, the CEDAW inquiry that was carried out found that the UK failure to protect women from harassment amounted to a breach of their Article 10 and Article 12 rights, as I mentioned before. So how can it be enforced? And the enforcement measures contained within this bill will give the police the ability to enforce the legislation if enacted. It will provide clarity to officers about what is and is not acceptable behaviour. And at the moment, the police are regularly called to deal with issues that are arising daily outside some hospitals and clinics, but rarely are they able to take any action because there's so many grey areas here with current law, and their hands are often tied, even if they do believe that women are being harassed accessing healthcare. And to go that little bit further, I have also included provision for unintended criminalisation, because it's not my intention to criminalise people unintentionally at all with this bill. This bill is concerned with regulating only a certain type of harmful behaviour that is directly and indiscriminately targeting women going into buildings that provide, or these people believe to be providing, terminations or information around reproductive health. So when a safe access zone is created, the department will publish the extent of the zone in order to raise awareness that it is now in operation. And then contained within the bill is a defence provision where someone, if they have no reasonable way of knowing that a protected person is in a safe zone, that they can use that as their defence as well. So that hopefully provides an extra layer of protection to avoid any unintended criminalisation. So I think that's the key sort of notes in the bill. I'm happy to answer any questions members might have.
Okay, thank you. Can I throw it out then to members? Gemma, you're indicating you want to?
Yeah, thank you,
Okay.
Chair, and thank you, Clare, as well, for bringing forward this bill. And it is a good bill, and obviously we're in support of it. Unfortunately, it is needed. We've all heard the horror stories that women and girls experience whilst accessing healthcare. Just two questions, Clare. The Protection from Stalking Bill will introduce a new offence of threatening or abusive behaviour alongside a new offence of stalking. So unlike existing harassment legislation, which requires an act to have happened to the same person on at least 2 occasions, this will cover either behaviour consisting of a single act. So has this new offence been considered when drafting your bill, and will there be any impact on your bill at all? Do you know?
Sorry, give me the last bit again, Gemma. Sorry, I didn't hear you well.
So, the new offence, has that been considered when drafting your bill, and will this impact your bill?
As compared to existing legislation provision?
Yeah.
Yeah, so under current harassment law, what's needed there is that one person has to target the same person on 2 or more occasions to have caused the offence, and then that needs to be reported, and then police can take action if there's evidence to support that, which is not sufficient in these cases, because very rarely would you get the same person accessing the same service or the same building on 2 or more occasions, or being approached maybe by the same protester. So it's when you think about more than one person in the protest, it would have to be the same person approaching the same person on 2 or more occasions. So that's where the flaws in that law fail to address what's happening at the minute. And then again with the public order offences as well, again this is waiting for harm to happen, and I think that at that point was made very well by Clare Sugden during the second stage debate as well. But the public order offences in the normal malls, that again wait for harm to happen, and then is maybe cost prohibitive to some people. But for that to be enforced for that person who maybe gets that order, accessing services in another time in the future, again, doesn't fit the picture of what's going on at the minute. And when it's cost prohibitive, again, not everybody is able to access those channels. And again, it's predicated on harm being done, where this bill is seeking to prevent harm from being done while facilitating a balance between competing rights.
Yeah, okay, yeah, fair enough. And my second and last question is, your bill doesn't introduce a penalty of imprisonment for someone convicted of an offence under Clause 6. What considerations did you have when deciding on penalties, and how did you conclude as you did for just fines to be handed out?
Yeah, and again, it's not, again, my intention with this bill is not to be very heavy-handed. It's not to be overly heavy with enforcement or sanction measures. It's simply to try and fill gaps in current legislative provision that will enable the PSNI, if required, to take what I would hope to be swift but minor actions in being able to move people onto a safe space. There is no imprisonment sanctions within this. The highest sanction that it goes to is a level 4 fine, which would be the equivalent to £2,500. But the first step is that if there is a breach, or if there is a report to the police that when the safe zone is there, that these types of behaviours can't happen, and that they have the powers to move people on. And I would hope that that would be the most effective, just to allow people to move elsewhere and continue what they're doing without interfering with someone's right to access. But it does go up to a level 4, and that's, on the chance that someone might be maybe repeatedly breaching the safe zone, or the sanctions within this that will allow the police to take further measures. But the first step is to allow the police to move people on, and then to forcibly remove them with reasonable measures if need be, before any fine would be imposed.
Yeah, no, that's fair enough.
And
okay,
sorry,
thanks again.
and just considering prison sentencing, I just didn't feel that it was a good way forward either. It would be a short prison sentence that would be required. I personally wouldn't be in favour of those myself, but I know that the courts are really reluctant to see those as effective measures as well. So, yeah, they were considered, but I didn't go down that avenue.
Yeah, no, I agree. That's fair enough. But no, Claire, thank you for that, and thanks again for bringing forward this bill. Chair, that's all my questions.
Thank you, Gemma. Can I throw it over to Rachel or Doug if you have any questions?
I've got a hand up. If not, I'll...
Go ahead,
Oh,
Rachel.
I'm happy to go. Thanks, Claire. Thank you for giving us a briefing of that. I'm obviously in favour of this bill, and did thank you for bringing it forward. I know that there was a number of issues brought up at second stage, and especially with people pointing to why would we not just change the harassment legislation. Well, that brings its own issues, as you've outlined, in terms of harm still needs to be done, where this is effectively trying to stop that harm happening anyway. I just want to ask about the examples from elsewhere during the debate. Liman was mentioned, and then in the EFM it was about another example in Ealing Council and Public Spaces Protection Order. And I know we were talking about balance of rights, but in your creating this bill and looking at other places, we mentioned in Australia and so on, you're not aware of any legal challenges that have ever been taken against balances of rights? Because I think that was a core argument during the debate was, well, this is very vague, this bill. I don't agree. I think it's very specific in what it does, but given that there are safe zones in other countries, you're not aware of any legal challenges being wrought against people's right to protest?
Well, any challenges would come exactly as you say in terms of that balancing of competing rights. So I think it's only fair that it was sort of set out what that balance is. And yes, people absolutely do have the right to protest and freedom of association, but that's a limited right, it's caveated, and the limitations that can be imposed in those circumstances, I have them highlighted, they have to be covered by law, which is what this bill seeks to do, have to be necessary and proportionate, and have to pursue one or more of the following aims in the interest of national security or public safety, which I feel this bill does, for the prevention of disorder or crime, which I feel this bill does, for the protection of health or morals, which again I feel the bill does, and the protection of others' rights and freedoms. So I do feel that this bill achieves a very good balance between these competing rights. And yes, there have been legal challenges to that in the past where zones have been implemented, and I suppose the closest case for us would be when they were imposed in Ealing. And they're in the financial memorandum to the bill as well, when we were trying to sort of assess the costs, implications to this bill, was really all we had to go on. So I think Ealing Council have spent up to 250,000 dealing with court challenges. But it's important then to note that the High Court ruled in favour of upholding the zones for Ealing, and when this challenge was then laid to the Supreme Court refused that challenge and upheld the High Court ruling.
Thank you. That's all from me. Thank you, Chair.
No other member? Sorry,
Yeah.
go ahead, yes, go ahead.
Yeah, thank you, Chair. And Clare, thank you. You have my support, of course. And I think this is something that needs to be done, and I thank you for bringing it forward. But can I just ask you, Clare, and I'm sorry, this is not a technical question. I'm trying to get a sense of something, if I can, please. And that's I'm trying to visualise these safe, these safe zones. So if I'm thinking about one, for example, at Craigavon Area Hospital, with one of these demonstrations take place every Tuesday evening, and I have to pass it every Tuesday evening, it's fine. But where it takes place is the only access to the hospital, but it's still quite some way away from the hospital. So when we talk about safe zones, or we talk about safe zones, which is a lozenge around the facility that we're looking at, whether that's a hospital or a clinic, or are we looking at a safe zone where there's a choke point where everybody has to pass through it in order to get to one of these services? And if that's the case, how do you do that when actually the road that's the choke point that people use to get into the service is actually the through road as well? Does that become a problem?
And this is I spent a lot of time on this, Doug, when we were coming up with the bill, and all buildings or premises are very different, which is why the bill is drafted for the Health Trust, the department, to come up with a zone that is specific to those premises. So the case that you're speaking about in Coleraine, for example, I feel has a natural buffer zone happening there already, where the protest happens without impeding people's safety to access, so you can maybe get the public transport, you can get to the car parks, you can get to the front, back, side entrances of that building without that interference. But that's not the same for other buildings. So in College Street in Belfast City Centre, for example, which is the Belfast Trust's main family planning clinic, it's in the busy city centre. So to measure that one in the same context as Coleraine Hospital is very different. How can staff maybe come and go without being impeded? How can service users, how can women or people accompanying them, and other building users, which is really important here as well, because in that one building, it's not just the family planning services. There are the blood transfusion services there. There's admin staff. I think it's payroll, can't remember, for example, all in there. So they all are impacted here as well. So the zone for that specific building would look very different than Coleraine. That would look, and in my personal experience, even in the same street in Great Victoria Street, when Mary Stopes Clinic was open, they were at one end of Great Victoria Street, and the Family Planning Association, for example, were at the other end at Shaftesbury Square. But even the geographical space outside both those buildings was very different. So Mary Stopes, for example, was on a very narrow pathway, heavy traffic, heavy pedestrianised area. There was telephone box, there were parking meters, there were billboards, there were cafes and seating, all in this very small, crowded space, as well as the protesters and people being able to access. And then at the other side of the street was Great Victoria Street, Shaftesbury Square, where the space outside the Family Planning Association was huge pedestrian area in footpaths, but very little footfall in terms of people. And then access to a bus or train station would have been very different than at the other side of the street as well. So it's sort of tailor-making that, what is safety and safety of access look for this particular site. And if a natural buffer zone happens, then that's grand. But as long as people can access the services freely, as long as staff can go about their business freely, which then is access to transport and entrances and exits, and that would be specific to a premise.
And Clare, thank you for that. It does paint a picture, so thank you. And on the issue of the protests, if they are absolutely nothing more than silent protests and placards with wording on it and maybe not images, is that something that as you envisage, that even with a safe zone, that would be something that would be allowed to continue or not?
This is about how people feel. We don't know how that's going to impact service users or staff that have to go through this every day. So I don't know what the wording would be. I don't know what this silent protest would be as well. But if the impact is to cause distress, fear or alarm, if it's to seek to influence someone's decision, then that's where the safe zone is needed.
Clare, thank you much, and thank you, Chair.
Okay, thank you, Doug. Clare, do you want to make any concluding remarks, or?
Just if it helps the committee, I know specifically to the Justice Committee, I have the PSNI are aware of this bill as well, and I will be meeting with them to go through the provisions here as well. But so far from their side, they're quite glad to hear that there will be provision that would allow them to take action if needed as well. So I'm hoping to meet them very soon as well. And if anybody has any further queries through the passage of this bill, I'd be more than happy if anybody even wants to come to me on a one-to-one and speak about any particular issues.
Okay, thank you, Clare, for your attendance today.
Thank you, Chair.
Okay, members, we return then to...
We just need to check that Sinead's not on.
Oh, right. Okay, can we check if Sinead Bradley is back on too? No, Sinead isn't back on.
Okay, members, with Sinead not back on, we are not to court to make decisions at the minute. So through the chair, if we suspended for 15 minutes for a short break. Sinead had indicated she'd be away for about half an hour.
Sorry, Chair. Sorry, Christine. With delegated votes, does that not make up a quorum? No.
No, we still need to have 5 members present.
There's Sinead.
Come back. Sinead.
Sinead, you're very popular.
Good timing.
You're very, very popular.
Stairs for them here now. Thank you, Chair.
Okay, thank
If you
you.
go back to start at agenda item 8 again.
Right, we're moving back to agenda item 8. Okay, members, thank you. Agenda item 8 is SL1, the Magistrates Court and County Court Appeals, Criminal Legal Aid Costs, Amendment Rules, Northern Ireland 2021. And members should refer to pages 238 to 298 of your meeting pack for the relevant papers. Can I remind members that at the meeting on the 23rd of September 2021, the committee considered a proposal for a statutory rule to amend the Magistrates Court and County Court Appeals Criminal Legal Aid Rules, Northern Ireland 2009, which prescribed the remuneration payable to solicitors and counsel for criminal legal aid in magistrates' courts cases and county court appeals. There is a statutory requirement to review the rules at least every 3 years, and the purpose of this statutory rule, which is subject to negative resolution procedure, is to give effect to proposals arising from the second statutory review. I would remind members that the committee agreed to request full details of the responses to the targeted consultation launch in July 2021, including any post-consultation report and sought clarification of the reasons for the large increase in the fee for remuneration for counsel in appeals against sentence to the county court. I can advise members that the Department has provided the post-consultation report outlined and the rationale for increasing the fee from £115 to £230. So can I seek the views of members on whether they are content with the proposal for the statutory rule, or whether any further information or clarification is required? Members? Members content? Members,
Content.
members are indicating content. Thank you, members. We'll then move on to agenda item 9, SL1, Magistrates Courts Amendment number 2, Rules Northern Ireland 2021. Members will find those at page 300 to 361 of the meeting pack for the relevant papers. Can I inform the members that the Psychoactive Substances Act 2016 created a blanket ban on the production, distribution, sale and supply of psychoactive substances in the UK. Members are advised that the Magistrates Court Rules Committee is proposing to make a statutory rule which will be subject to negative procedure to incorporate a number of provisions in the 2016 Act within the Magistrates Court Rules. The provisions relate to the variation and discharge of prohibition and premises orders, the use of special measures to protect vulnerable or intimidated witnesses in proceedings in respect of these orders, and to determine which court has jurisdiction to continue a case when a respondent turns 18 during ongoing proceedings within the youth court. So can I seek the views of members on whether they are content with the proposal for the statutory rule, or whether any further information or clarification is required? Members?
Content.
Members are indicating content. Members are indicating content. Can I move then to agenda item 10, SL1, the County Court Licensing Rules, Northern Ireland 2021. They will be outlined on pages 363 to 368 of the meeting pack. Can I inform the members that the County Court Rules Committee proposes to make a statutory rule which will be subject to negative resolution procedure to amend the County Court Rules Northern Ireland 1981, which prescribes the forms to be used and the information to be provided in an application to a county court under the Licensing Northern Ireland Order 1996. I advise the members that amendments are required to some forms consequential to the Licensing and Registration of Clubs Amendment Act Northern Ireland 2021 provisions in relation to further later opening hours for public houses and for hotels, and the alignment of closing time for liquor and entertainment. So can I seek from the members their views on whether they are content with the proposal for the statutory rule, or whether any further information or clarification is required? Members content?
Content.
Members are indicating content. We'll then move to agenda item 11, SL1, the Magistrates Courts Licensing Amendment Rules, Northern Ireland 2021. And I refer members to page 370 to 376 of your meeting pack. I inform the members that the Magistrates Court Rules Committee proposes to make a statutory rule which will be subject to negative resolution procedure to amend the Magistrates Courts Licensing Rules Northern Ireland 1997, which prescribes the forms to be used and information to be provided with an application to a Magistrates Court under the Licensing Northern Ireland Order 1996. Members are advised that amendments are required to some forms or new forms are required consequential to the Licensing and Registration of Clubs Amendment Act, Northern Ireland 2021 provisions in relation to the removal of additional restrictions at Easter, further later opening hours for public houses and hotels, and the alignment of closing time for liquor and entertainment. So can I seek the views of members on whether they are content with the proposal for the statutory rule, or whether they want to seek further information or clarification? Members content?
Content.
Members indicating content. We then move to agenda item 12, the SL1, the Magistrates Courts Fees Amendment Order, Northern Ireland 2021. Agenda item 13. We're taking these two together, Christine?
Yes.
We're taking, sorry members. Agenda item 12, SL1, as I've just read out, and agenda item 13, SL1, the County Courts Fees Amendment Order, Northern Ireland. And we're taking both of the items together. So can I refer the members to pages 378 to 392 of their meeting pack for the relevant papers? So can I inform the members that the Department of Justice intends to make two statutory rules under section 116(1) and 4 of the Judiciate Northern Ireland Act to prescribe fees for new licensing applications arising from the Licensing and Registration of Clubs Amendment Act 2021, which inserted new articles 44A and 44B in the Licensing Northern Ireland Order 1996 in relation to further additional permitted hours for public houses and hotels. The rules are not subject to any assembly procedure. And I advise members that the licensing applications fall under civil court business for which court fees are charged. The Northern Ireland Courts and Tribunal Service has assessed the work required to consider the new applications and the fees charged for comparable existing applications, and considers £354 to be appropriate for each Article 44A and 44B application. Until the fees orders are amended to include the specific fees, an interim fee charging position is in place whereby general application fees are being applied, now valued at £130 for applications to the Magistrates Court and £151 for applications to the County Court. The Northern Ireland Courts and Tribunal Service has also highlighted the further amendments to fees has also highlighted that further amendments to fees are likely when future licensing reforms are brought into operation. So can I seek the views of members on whether they are content to note the two proposals for statutory rules to prescribe the fees for new licensing applications arising from the Registration of Clubs Amendment Act 2021, or whether they wish to submit any further views or comments or require any additional information. Members.
Chair,
Gemma?
can I, a couple of questions?
Go ahead, Gemma.
Yeah, I just want further information on how did the Courts and Tribunal Service arrive at the £350 figure? What's the current fees for licensing applications? And has the Department of Communities provided a view on these fees? And then I'm not sure, I didn't hear, but during each stage of the bill going through the Assembly, were fees discussed at all?
Sorry, can we take Christine?
Yes, if the committee's content, we can write to the department and get that information.
So you're content that we do indeed, as the clerk has advised, write to the committees, write to the seeking information. Okay. I mean, I was on the communities as the bill was processing through. I have to say, I'm not sure myself that fees were discussed. But having said that, I think they're comparable to existing fees for other pieces of similar applications being made. But obviously, we'll seek a clarification on that for you, Gemma.
Okay, thank you.
Okay, Clare has indicated.
Rachel.
Sorry, Rachel.
You're all right.
Sorry, Rachel has indicated. Sorry.
So no, it was basically exactly the same there as Gemma. Current court fees for applications are nowhere near £354 for a late licence, and declaring interest is to apply for them. In terms of consultation as well with stakeholders and industry bodies, I took part in that licensing bill. Fees were not mentioned at all. Those were the sorts of details that the industry bodies wanted to know about applications, and we're told that that would come later. So in terms of how do they know about this? Is this something that they have been involved in? I'm not too sure if that's the courts to do that, or indeed the Department for Communities. But if these fees are going up, when are they going up? And I note that the department has said in both of these statutory rules that there has been significant media coverage regarding the commencement of provisions. That's the commencement of these provisions. That's not when the businesses are going to start being expected to pay more. So I wonder if there has been any communication from either the Department of Justice via the Courts and Tribunal Service, or indeed the Department for Communities, in relation to pub owners, hoteliers and industry bodies about that these are coming and when. Certainly I wouldn't like to be a pub owner going for my first late licence to 3 AM and getting hit with a £354 fee without notice, especially given the current climate. But just if we can certainly get some clarity on those issues.
Okay, are you content along with Gemma that we write to the communities and justice?
Yeah, absolutely.
Okay, thank you. Members? Okay. Okay, so based on what we've said, Christine will write to the two departments seeking the information. Okay. Agenda item 14, stopping domestic and sexual violence and abuse, the 7-year strategy, year 6 action plan update. And I refer members to pages 394 to 407 of your meeting pack for the relevant papers. I remind members that at the meeting on 6th of May, the committee considered the 6-year action plan for the Stopping Domestic Sexual Violence and Abuse 7-year strategy, which sets out the programme of work to be delivered during the 2021-22, and agreed to request an update on delivery of the plan at the end of October. I advise members that the department has provided the update on delivery against each of the relevant actions relating to the department and criminal justice papers. Can I ask members to note the update and seek agreement to request a further update on delivery of the year 6 action plan in March 2022, unless any further information or clarification is required?
Gemma.
Gemma?
Yeah, sorry, Chair. Can I do approve of it, and I welcome the action plan report, but just on action number 19, promote the Ask for Annie code word scheme. Will there be a list of the pharmacies that are participating available? I've looked online, I can't get any. And then action number 36, on the use of mobile phone technology. I'm just wondering, could we get maybe a written briefing on how that works? In theory, it sounds really good, but I just don't know how it works practically. So if that would be possible, it would be appreciated.
Okay, can we ask Christine maybe to follow up on both those items for the members of the committee? Okay, thank you.
Rachel.
Okay, Rachel.
Yeah, just on a couple of queries just from the update. With regard to the MARAC referrals, it says that internal workshops and guidance to support an increase in the referral rate to MARAC are being developed. Can we get an idea of the current referral rate to MARAC and what options are being considered?
Okay. Any other members? No. Okay. So apart from those two queries, apart from the queries raised by the two members, are members content that we then seek a further update on the 6-year action plan in March 2022? Members agreed?
Agreed.
Members agreed. Okay, thank you. Then we move then to agenda item 15, EU exit and justice-related issues. I refer members to their meeting pack on pages 409 to 429, and remind members at the meeting of the 23rd of September, the committee considered an update from the Department on EU exit and justice-related issues and correspondence regarding the government's response to the Northern Ireland Affairs Committee report on cross-border cooperation on policing, security and criminal justice after Brexit, and agreed to request additional information on a range of issues. I advise members that the Department has provided further information on ASNI funding in relation to Brexit and the protocol, the current extradition arrangements with Ireland, and details of the impact of the EU's exit from the Lugano Convention. It will also provide an update on the outcome of the Specialist Committee on Law Enforcement and Judicial Cooperation following its first meeting, which was scheduled to take place on October the 19th. So I ask members to note the additional information provided by the Department unless they want further clarification prior to receiving an update on the Specialist Committee meeting. Members content? Members are indicating content. I move then to agenda item 16, Domestic Abuse and Civil Proceedings Act, Northern Ireland 2021, implementation of Section 28, Domestic Abuse Waiver for Legal Aid, and an update. I refer members to pages 431 to 450 of the meeting pack for the papers. Members are reminded that at the meeting on the 16th of September 21, the committee considered an update from the Department of Justice on the implementation of the Domestic Abuse Waiver for Legal Aid, which indicated that the waiver for legal aid for victims of domestic abuse in responding to Article 8, Children Order proceedings, will be commenced at the same time as the domestic abuse offence, and agreed to request further information on the timescale for completion of the online business case and a copy of the online business case, including the options considered. The committee also sought confirmation that the Department has fully explored and concluded that there is no repercussive effect, and requested a copy of the paper to establish this. I understand, Sinead, you want to make some comments? You're on mute, Sinead.
Sorry, Chair, apologies for that. Yes, no, it was just to have a clear record, as I indicated at the last meeting, because this was a big blockage in terms of this bill, and it actually stopped it moving at one stage on the floor of the House. So I just wanted there to be clarity and a paper trail on what repercussive effect actually is and when it merits flagging it, because ultimately it's something that could hamper quite a lot of work of this assembly going forward if somebody was minded to use it. And therefore I think, given that it has come through this committee and it was teased out quite significantly, I appreciate the work that certainly Christine and the clerk and the officials have done in trying to set the record straight on that. Not sure that it absolutely has clarity, to be fair, but I think we as a committee have been endeavouring to do our best to set that clear record. Thank you, Chair.
Thank you. Okay, thank you, Sinead. Rachel?
Yes, thank you, Chair. Just a bit confused just in terms of what are the information that we requested by committee on the 1st of October was a copy of the outline business case, including the options to be considered for the evidential test or test to be applied for by LSA, and a copy of the relevant paperwork that confirms that there's no repercussive effect. So just for clarity, that is not what we have in the letter from the department. So without sounding tedious, can we ask the department again for the things that we asked for them in their letter, in the letter on the 1st of October, because that letter on the 12th does not give us the information that we requested. If it's unavailable for various reasons, fair enough. But there certainly isn't the detail that the committee asked for. And the department would be fully aware about why the committee would like to have a look at that. I believe that we've been asking for some time for those papers, and especially if the Section 28 is going to be commenced at the same time as the offence. I believe that to be February next year, so it might be something that we would want to look at before that does happen.
Okay, let me just add a wee bit more to it then. Can I advise that the department, Rachel has indicated that the OBC is being developed with the aim of sending it to the Department of Finance for consideration no later than the end of November, and indeed that it will consider the options for the evidential test to be applied by the Legal Services Agency in applying the waiver. It also considered the contributions which may be paid by legally aided clients. The Department has also advised that the Department of Finance approved a strategic outline case which considered the risk of potential repercussive effect, and a further update will be provided in January, which will include information on the communication strategy to raise awareness of the waiver. Are you?
Yeah, I think, Chair, it might be helpful if perhaps, based on what Rachel has said, that we go back to the department and clarify. It may be that they're not in a position to share the outline or the business case until it goes to the Department of Finance, but if we clarify that and make sure that we get a copy of it when it is available. And we will also highlight that we did request the paper trail, which we haven't got, and request that again.
Okay.
That
well,
might.
Are the members content then with the advice of the clerk there, that you're happy enough that we follow that route? Members content?
Agreed.
Members are indicating content. Okay. Agenda item 17, the development of a joint secure care and justice campus for children. It's an update. I refer the members to pages 452 to 513 of the meeting pack for the relevant papers, and remind members that at the meeting on the 16th of September, the committee considered 2 responses from the department on specific concerns raised by members and the Children's Commissioner in her assessment of the Northern Ireland Audit Office report on managing children who offend, a follow-up review and the issues and concerns raised in relation to youth justice in general, and the development of a joint secure care and justice campus for children, specifically by a number of representatives of children's organisations. I remind members that the committee agreed to request further information on a range of issues, including details of the factual inaccuracies referred to by the department in the Tracing the Review research report, and a copy of the mapping exercise of available services for early intervention to secure care and aftercare, and advise members that the department has provided a detailed response setting out the information requested. It will also provide a written update on the secure care and justice campus programme for the committee meeting on the 20th of January 2022. I ask members then to note the additional information provided by the department unless any further clarification is required. Can I seek the agreement of members to forward a copy of the response to the representatives of the children's organisations who attended the informal meeting with the committee members in July for their information? Members are indicating content. Thank you, members. We move to agenda item 18 then, correspondence. I inform members that there are 4 items of correspondence at pages 515 to 569 of the meeting pack, and 1 item at pages 186 to 202 of the tabled pack. I advise members that draw your attention to item on Members, let me draw your attention to the item on the table pack, and members will then have an opportunity to comment on any other items of correspondence in which they have a particular item interest. Item 18.6 at pages 181 to 202 of the table pack, and it's a copy of the Public Accounts Committee report on speeding up the justice system that was published today. I remind members that at last week's meeting, the committee considered information from the Department of Justice on the time taken for criminal cases to go through the criminal justice process and the programme of work being taken forward to tackle delays in the justice system, and agreed to consider the issue further once the Public Accounts Committee had completed its inquiry on speeding up the justice system. I advise members that the Department is required to respond in writing to the PAC report findings and recommendations, and the PAC committee will consider that response. This committee can consider the issue further once that report process is complete. Members content? Members are nodding to indicate content. Members are content. Okay. I ask members if they are content to action the items of correspondence then as set out in the cover sheet, or whether they have any comments or wish to discuss any of them. No. Members are indicating they are content with the action items on the correspondence. Okay, thank you, members. Then move to item 19, the chairperson's business. I have no indication from the chairperson that he has any business to report. We'll then move on to agenda item 20, any other business. Ask the members if they have any other business that they wish to be considered. No indication of any other business. I move then to agenda item 21, the date and time of the next meeting, and I advise members that the next meeting of the Justice Committee will be held on Thursday the 4th of November 2021 at 2 o'clock in room 30, Parliament Buildings. I thank the members, small but very important group that we were today, for their attendance, and no doubt normal service will be resumed at the next meeting. So thank you, members, for their forbearance. Thank you.